Good afternoon, everybody. My name is Chris Justice, and I am here again today to join you, hoping to answer as many questions as you all have, anything related to employment law. I'm an employment lawyer, as many of you know, with Samfiru Tumarkin. I work out of the Toronto offices. And as I say, as you see down below there, get your answers to questions live. So any questions you've got could be maybe a question about a contract you're wondering about signing. Maybe you've got a question after you've been let go from a company. Maybe you're going through some issues in the workplace while still working there and you've got some questions. So whatever it is, do get your questions in. And as always, I'll do my best to answer as many as I can today. As I also normally do, I like to start off with a few topics from the outset while everyone gets their questions in. And today I wanted to focus on the issue of independent contractors. Nowadays, over the last several years, our economy has been shifting to one of what's referred to as a gig economy. A lot of different types of jobs, different formats in terms of how people are working these days that just weren't typically the case back before that. You've got people like Uber drivers and Lyft drivers who are wondering whether or not they're employees. You've got people who, are being termed as independent contractors or some form of a consultant, and they don't know necessarily if they're considered an employee under the law. So there's a lot of different labels, a lot of different titles that get given these days that aren't necessarily your standard employee-employer relationship. And so it can cause some confusion when different terms get thrown about. And a lot of times I speak with people who are essentially being told by their employer that they are an independent contractor, that they do not have the same rights and entitlements that an employee would have under the law. For example, one big right or entitlement that an employee would have is an entitlement to severance. And in this particular country, you can get upwards of 2 years of severance if you're an employee and you've been let go from your job. However, if you're an independent contractor and you've worked for a company for decades and you're let go, technically it could be possible that you are not considered an employee, and so you wouldn't be entitled to any severance. So just on the issue of severance alone, the difference between being considered an employee or an independent contractor can, impact a lot as far as the dollars and cents are concerned. Not to mention getting into things like whether you're entitled to vacation pay, statutory holiday pay, overtime, certain types of leaves of absences that you need to take. A lot of these things are covered when it comes to an employee, but not necessarily in every situation if you're not an employee. So again, all the more reason why, if you do have a question or a concern about whether you are considered an employee or not, maybe you've got a contract that says you're not. First of all, don't worry about that. A lot of times there are a lot of factors that go into whether someone is an employee or not. And it's not simply a matter of, a contract saying that you're not an employee, or just because your employer says you're not an employee, that you're therefore not an employee. It's actually the law that determines whether you're an employee or not. And in a nutshell, a couple things that the law focuses on when trying to decide is one person an employee or not is the level of control that the company has over that individual. So if you are, let's say, an independent contractor by title, but you go into work every day, Monday to Friday, you've got a company email, or maybe you've got a business card with your name and the company logo on it. Maybe you take a lot of direction from someone that you report to. Someone else decides maybe your hours that you work, the tasks that you perform. So in these scenarios, if you're being connected with the company a lot and the company otherwise has control over sort of what you do and how you do it to some extent day to day, then those are going to be big factors weighing in favor of the law saying you're an employee. Even if you've got your own company, even if you pay your own taxes, even if you invoice the company yourself on a monthly or bi-monthly basis, whatever it is, these facts are not going to be enough alone to decide if you're an employee or not. And so in my experience, I find that there are a lot of people who invoice the company. There are a lot of people who pay their own taxes, who have their own corporation that the money goes through. But then there's another 10, 20 factors that are more employee-like. As I said before, maybe working the same number of hours, consistently being paid the same thing, working only with one company for as long as we're talking about. So you definitely want to give us a call if you are in a situation like this where maybe you don't know if you're an employee or not. Because, unfortunately, there are a lot of people who think that they're an independent contractor, who don't think that they're an employee, who work for a company or with a company for decades or several years, and then they just leave and think nothing of it, thinking they're not owed severance or anything, when in a lot of cases, if not the majority of cases like these, they are actually entitled to severance. So don't fixate on if someone's calling you an independent contractor. You don't decide who's an independent contractor. Your employer doesn't decide that. It's the law. And as I say, depending on which way it goes, you could be looking at significant entitlements that you may not have even been aware of before. But I thought I'd talk about that to begin with, because again, this sort of shifting economy, you've got different names for different things. And it's not always clear, like it was back in the day, that somebody is an employee deserving of those protections under law. I'll get into some other topics I wanted to touch on, but I will start answering some of your questions. So do get your questions in. Definitely happy to answer as many as possible. As I say, I'll start with Sir on YouTube, who is saying that they work 2 jobs and they were let go essentially from one of the 2. They are looking to collect damages or perhaps severance as a result of losing one of those 2, but they ended up taking work similar to the job they still had. And they're wondering if this counts against damages. So essentially, if you have 2 jobs and you lose one of those jobs, then normally, as long as you don't get a replacement job, you can still go after severance for the job that you lost, even though you may still have a backup job making money. But on the other hand, if you have 2 jobs and you lose one job, but then you replace that lost job with another, so you're back to having 2, then the fact that you found a new job after you were let go is in a lot of cases going to affect how much compensation you can get. A lot of times people have 2 jobs and they lose one, but they don't necessarily replace that one with a second one, and they just have the one left over. And they'll often ask me whether those earnings count against their damages. And in general, the answer to that is no. As long as those earnings don't change, if you're making, say, $20,000 a year at one job and $10,000 a year at another, and then you lose the job that makes you 20, but you just keep making 10K at the one you had already, then that's just going to be status quo. And that's not really going to factor in at all in terms of damages that you're owed for severance. But again, if that 10 or that 20 grand that you lost gets replaced by another 10 or 20 or 30, that's when, yes, it could affect to some extent, at least, how much severance the employer who let you go may owe you. So that applies in general. Anyone who's lost a job, who is able then afterwards to relatively quickly find another job, that has to be factored into their severance. A lot of time people think that if they're owed, let's say, 12 months of severance, then it doesn't matter whether they have a job or not. Their employer or their former employer should pay them the 12 months. And then if they so happen to have another job making money elsewhere, too bad, so sad, they still get their full severance. And just to clarify that misconception, it's not always the case. And in a lot of those cases, if you haven't settled your matter with your former employer, earnings like that can factor into the equation. But thanks for your question, sir. I've got another question in from Ruel on YouTube, who's asking whether or not an employer can rescind a job offer after they've signed it. This individual is mentioning that they had a pre-planned vacation after 4 months. So I take that to mean a vacation after 4 months of the start date or the proposed start date with the company. So technically, I guess, an employer could rescind a job offer, but if you have signed it and you have signaled your acceptance of the terms of that deal, in a lot of cases, and maybe in most cases, that alone is going to sort of signify that there was an offer made and an acceptance of the offer. And so now a contract has been created. And there are even cases where the person doesn't even get to work the first day but they've signed a contract and there has been an agreement in place, and then the employer rescinds the job offer or tries to pull it back. And even though that person didn't work a single day, they can still potentially get severance as though they had been let go. Sometimes it may depend on whether there's a termination clause in the contract. It may depend on whether there's a probationary period in the contract and what that could say. But there are, as I say, instances where you don't even have to have necessarily worked a day. If there's already that offer and acceptance that can be proven, then the employer may not just simply be able to rescind the job offer and not be on the hook for any damages. And there could actually be some liability there. So without having, I guess, a bit more information on that front, I would just suggest you give us a shout. You can set up a consultation with one of our lawyers, and we can kind of go through the details themselves, Ruel, as far as, what the offer says, what terms are in that offer, as I say, whether there's something in there that could affect things. But we'll at least be able to give you a good idea of what your options are, and you can go from there. But that's a good question. It doesn't come up a ton, but in situations where it does, it's good for people to know. I've got another comment or question in from Sam on YouTube, who's saying that we have great content. So thanks for that, Sam. And you're saying most of what is discussed in this session is worthwhile in the scope of the workplace. So I do appreciate the comment, Sam. I do agree. Of course, I don't want to make it seem as though this should replace any full-fledged consultation you guys want to set up with us. This is sort of to kind of touch on a lot of the surface level issues, but at least it can kind of spark in people's minds, that they may have options, that they may have a need to get further legal advice. And again, that's partly why we do this, is to kind of trigger that for people so that they can kind of get in touch with us. And as I say, in a lot of cases, you find out, even unbeknownst to yourself beforehand, that there's a lot of potential there. But I thank you for your comment there, Sam. I've got another question in from Bronto, who's asking whether or not an employer can restrict you or prevent you from basically taking a second job. And again, technically or practically speaking, that wouldn't seem likely that they could do that. Although a lot of employers, when you join a job or join a company, there's going to be something in the contract, if there's a contract you sign, that says you agree to devote your full time, effort, energy, attention to this job. And depending on the nature of the job, a second job may or may not be in the cards. So for instance, if you've got one job that you have to work 60 hours a week, and you've got a contract that says they expect you to devote all your time and efforts into the one job, I mean, you could get a second job, but then the question is, how many hours are left in the week for you to do the job? And do you sort of end up suffering from the first job by devoting more of your attention and efforts and energy to the second one? So there is the potential for a bit of a conflict there, though it's not necessarily illegal or an issue to take a second job. It just often will come down to how much time and effort is required, and is that going to detract from your ability to do the first job? So that's number one issue. And then a second issue is, even if the job doesn't take away from your ability to do your first job, then you got to look into the nature of the job too. So are you working for a competitor? Are you working for or in an industry where maybe trade secrets could be exchanged or confidential information could be exchanged? The employer might have a worry about that. So it may also just depend on the specific employer that you're working with as your second job. But as long as you can do both jobs with best efforts and not have it detract from one another, and as long as there's no conflict of interest in terms of the nature of the work itself between those two jobs, an employer is going to be hard pressed to restrict you completely from taking another job. There may be a situation where it's good to raise it with the employer to give them an idea of what you're planning on doing, just to make sure that there's no issue there. But strictly speaking, no, an employer can't restrict you. But in some circumstances, you could be putting yourself at risk, or at least at risk of just annoying the first employer, which could end up in the loss of your job as well. So that's more of a practical effect. But Bronto, again, if you want to flesh out your situation a bit more for us during a consultation, we can definitely talk about it with you in greater detail and just kind of give you an idea again of sort of what your options are, pros and cons of going down one path or another. But thanks for your question. I've got another one in from Sheila. Sheila is saying that an employee's pay is being changed by around or more than 16% with reduction with the employment standards and notice period. Can it be constructive dismissal after the ESA notice period? So I guess a situation that you're describing is one where you have been let go. And let's say at the time that you're let go, you were earning $100,000 a year. But from the date of your termination forward, or for part of the severance period, your employer, I guess, refuses to pay the wages that you would have earned had you still been there. If that's the case, then your employer is likely not giving you the proper amount of notice or the proper amount of pay in lieu of notice. They would have to show that, had you continued to work there as an employee after you were let go, they'd have to prove that your earnings, had that happened, would have been lower than what they were at the time you were let go. And that seems to me like a pretty hard battle to win for them. It's not technically impossible, but for the most part, when employers kind of change around your pay after you've been let go, a lot of times that can definitely be considered improper notice or just an unfair severance package. And a lot of times you're going to have to get a lawyer involved to kind of argue that, if you're owed, say, a year of pay, that they're not giving you 75% of a year without some amazing justification, which I can't even think about right now or think of right now. So that would raise some alarm bells for me. And Sheila, if this is happening, you definitely want to make sure you get your full, not just your full ESA notice or severance, but just your full common law notice and severance. And again, if they're sort of changing things after they've let you go and you're not even getting a full week or month or year of pay, whatever it is they've offered, definitely want to give us a call so we can kind of flesh that out. Thanks, though, for your question. Anytime somebody in general takes a reduction of 15%, I would say, or greater, just from a compensation standpoint, that in most, if not all cases, on its own would be a constructive dismissal. So again, thank you for that question. It's important. I've got another one in from Francine on YouTube, who's asking whether or not an employer can change their workplace without considering any accommodations. And if the accommodations you're talking about, Francine, are human rights related, so it could be, age related, could be disability related, whatever it is, if there's some sort of human rights component to it, and you require those accommodations going forward, first of all, you want to make sure you have the support of your doctors. So some kind of letter or note, medical note that says what your restrictions are, what your limitations are, and essentially what accommodation you need. If you've got that in place, and assuming the accommodation isn't too burdensome, which for the most part it isn't, even though employers like to pretend it is, then your employer does have to accommodate your request. In order for your employer to refuse to accommodate your request, it would either have to show that by virtue of accommodating your request, they would incur what's called undue hardship, which is essentially, in a lot of cases, a ton of money or pain and inconvenience beyond your normal just, pain or inconvenience, but undue hardship. So that's a high threshold to meet, and they'd have to prove that to reject your accommodations, or in some way try to argue that you are not able to do your job even with those accommodations. And they'd have to show generally that the vast majority of your job you wouldn't be able to do. So if they can't do that, or they can't prove some case in justification of their decision, then yeah, rejecting somebody's accommodations, especially if it's human rights related, is going to lead to the risk of a human rights violation. And then you may have grounds on that basis to treat your employment as though it's been terminated by virtue of their failure to accommodate, and go after them potentially for not just severance, as though you'd been let go without cause, but also you could go after them for human rights damages, bad faith related damages. So there could be a lot there for your employer to have to think about. And so, yeah, Francine, if you're going through some issues with respect to failing to accommodate your needs or whatever it is, then definitely give us a shout, because there's a lot going on in these types of cases, and you want to make sure that even when you're communicating with your employer about accommodations, that you say the right things and kind of have a paper trail, have a good record in place, so that if there is some sort of dispute later on down the road, you can kind of refer back to certain things. But again, not without, I would say, legal advice. So reach out to us, and like the others, we can kind of talk you through it and see what help we can be. Thanks for your question, though, Francine. I've got another one in from Sherry. Sherry's saying that they're on a PIP, which is a performance improvement plan, that they think is unfair and discriminatory. So on both those counts, if it's unfair, the question is, why is it unfair? And if it's unfair because it's just full of lies, that's one thing. You want to point that out in writing to them. If it's unfair because not so much that there are lies, but the expectations are extremely unrealistic and you feel as though you're being set up to fail, then that would be another point that I'd want to push back on and make record of. So anytime someone's put on a PIP and it's unfair, you want to sort of distinguish what you mean by unfair, the ways in which it's unfair, bring that to their attention so that you do have that record, so that if they ever try relying on it later on, you can point back to your objections, your pushback, or you pointing out sort of the unfairness or the inaccuracy of the performance plan itself. And then that's going to give the company less of a leg to stand on if they're going to try to use it or other warning related stuff as a means to letting you go for cause. So that's number one on the unfairness. On the discriminatory part, a lot of people come to me and they talk about how they've been discriminated against. And what they really mean is that they've been treated differently than others, but not necessarily that they've been treated differently than others because of a human rights related ground. So maybe there's a slight difference in the situation of someone being treated differently than others because of some, let's say, personality conflict or personal issue, and then someone being discriminated against and sort of being, let's say, given a performance improvement plan because they're a woman or because they're Black or they're of a certain age or they're disabled, right? So these are not all of the grounds for human rights related stuff, but some of the main ones. And so if you can make the connection between one of those grounds and you being given this PIP, and let's say it's not just because, I don't know, someone doesn't like you and has a vendetta against you, then yeah, that could also involve discrimination. And that also would be something that you'd want to make a record of and establish for sure. So, but those two things are both very serious potentially, unfair PIPs and discrimination. So just going a little bit further, Sherry, into your statement or scenario, you're saying that HR may revoke the PIP after you show evidence, but you still think they want you gone. Should you drag things out to get more money or negotiate an exit now? So you could potentially exit or negotiate an exit package now if you can show that the PIP is extremely unfair and discriminatory. There are actually situations where just by being given a PIP on its own can result in a constructive dismissal and can give you the option to leave without necessarily having to wait around for them to let you go. But you usually have to have really good evidence and a really good set of facts, and as I say, proof around the unfairness and the discrimination. And it's going to part boil down to what exactly you have. But if HR revokes the PIP after you show them evidence, then in a way, that's them sort of acknowledging that they were unfair or something along those lines. And if they strike that from your record, that is going to help them avoid a constructive dismissal claim, if that makes sense. Because then presumably they would say that they want to welcome you back open arms and that it won't happen again, and whatever the case is. Now, are they telling the truth when they say this stuff? Hard to say. You won't really know probably until you actually stick around. But that decision of theirs to revoke the PIP, as I say, could help them. If they don't revoke it and they just dismiss your concerns and you have solid evidence of unfairness and discrimination, however, then I go back to what I was saying a minute ago, which is just being given the PIP, if it's in that bad faith of a nature, could allow you to leave. If it's not that bad faith, or if it's a less egregious situation, then it may not give you as much of an out to leave now, but it would still be something you'd want to make a record of now, so that if they ever do try relying on it later, you can kind of, nip them in the bud there. And then if they, because oftentimes they'll try to build a case against you for cause. If they try letting you go for cause later, then you can use all this information and evidence to show that it's a without cause termination, and go after them for the severance. So in part, Sherry, to kind of depend on some of the details based on what you're saying, but that would be my comment on your part one. And then part two, you're saying you're concerned about future layoffs and whether this could diminish your leverage for a better severance, especially after voicing these issues, and you're asking whether you could still claim wrongful termination and seek extra pay. So when you say layoffs, I assume what you mean is a termination, because a layoff in the law sense technically means a temporary layoff. But there's nothing really stopping your employer from terminating your employment. If they're going to do that, they can do that for whatever reason they want, as long as it's not outright discrimination. And again, it'll come down to your ability to prove that. But if you can't, then they can let you go pretty much for any reason. They just have to pay you severance. Now, you voicing your concerns is not going to diminish your severance, I don't think. That's not really a factor that the courts look at when deciding how much severance to give someone, unless you can show that maybe you were let go as a form of retaliation for bringing those concerns. Then you could open up a further bad faith sort of can of worms there. But you have to show specifically that the termination happened because you raised your voice. Barring that, the you raising of the voice in the past won't matter so much, but it will just be a matter of making sure your severance package is otherwise fair and reasonable. And yeah, you can claim wrongful termination if you feel you've been essentially terminated by virtue of the PIP. You have 2 years from probably the day you were given that PIP to start a lawsuit if you want to go after them for a constructive dismissal due to the PIP. But again, sometimes it may not make sense to do that right away because you don't have as much of a leg to stand on. And sometimes it makes sense to wait to see what the company's response is to you voicing concerns, maybe wait for them to drop the ball even more so. And then if anything, you'll just have more leverage to get a settlement package later. But yeah, that I think is would be my comments for your part two, Sherry. Again, if you want to schedule a consultation, talk through this in more detail, happy to speak with you. I know we've got a lot of lawyers that are very willing to help out. And I know your particular case, it seems like, has a lot of issues going on, from future layoffs to PIPs to discrimination to, raising concerns. But definitely give us a shout. And thank you in any case for your questions. I've got a couple more questions here. I'll try to answer some just before we end today. I've got a question in from Helen on YouTube, who's asking if the BC, the British Columbia Supreme Court, awards similar compensation based on Ontario's cases. And yeah, in general, aside from, I'll say, Quebec, because they're operating on civil law, the other provinces are common law. So British Columbia, Alberta, Ontario, of course. These are all typically common law provinces. So if you're owed severance from a common law perspective, the arguments would generally be the same, whether you're in British Columbia or Ontario. There is some difference between the legislation in these provinces, but that's the legislative side. That's not common law. But in general, for the common law, yes, there's supposed to be some consistency across the board as far as these provinces are concerned. Sometimes you might say BC is more generous to some extent than maybe other provinces when it comes to employees. But in general, there should be that line of consistency that I would expect. I've got another question in from Sam, who's asking if there's any way to pose a multi-part question with the intent to lengthen what is acknowledgeable for exclusivity rights, and under what circumstances can it be stated silent communication be relevant in corporate settings. Sam, I don't know if I can answer these questions. It seems like more of a corporate business law type question, but if you want to give us a call, maybe flesh it out a bit more, I might be of some help. Maybe I'm just not understanding what you're writing here. So do give us a call if you're interested in setting up a consult, and we can at least tell you what, if any, help we can be. I've got one last in from Sherry, just as a follow-up. She's been struggling psychologically due to the PIP and the discrimination, and she's wondering if she should ask for therapy accommodations. Could this make it harder for them to fire me and buy more time? Yeah, I think if you are seeking accommodation, medical accommodation, as a result of let's just call it a toxic workplace for lack of a better phrase, then again, the normal accommodation right should normally be triggered on the employer end. And if it's something that wouldn't cause them undue hardship, then they should look into that. So if you, let's say, had therapy appointments with a psychologist or psychiatrist on a given day or week or whatever, I would expect the employer to make accommodations to allow you to attend those appointments. And yeah, the optics of the situation are probably going to make it harder for your employer to fire you while you're getting these sorts of accommodations, just from an optical standpoint. To be sort of accommodating someone, or maybe if you're coming back from a leave of absence or you're on a sick leave and you get let go, doesn't 100% mean that it's discrimination, but it looks really bad. And for that reason, I find that employers will try and maybe wait for the dust to settle, so to speak, before terminating someone's employment and sort of having that connection still be there. But again, give us a shout, Sherry, to speak about it further. That's my time for today, actually. So thanks, everyone, for your questions. I'll be back. So if you've got any more, just stay on the lookout. Although we do have often a lot of other lawyers from our firm answering questions just like I've been. And in fact, we've got one with Lior Samfiru himself this Wednesday. So if you have any questions that weren't answered, or maybe you want to have a question saved for that day, tune in then, chat with Lior, and I know he'll give you the answer that you need. But thanks again, everyone, for showing up and joining us today. Do take care. Enjoy the rest of your day. Bye for now.